Now going forward with this, let us talk about the issues which we are going to raise from this international taxation legal framework, and the issues in the sense ki whether the principles and whether the legal framework can be applied to the digital economy and the e-commerce world or not. Now let's talk about the transactions of the digital companies, which we started talking about with. Now, first of all, as a digital company, I might be having various transactions. I might be selling online advertisement services to some company which is resident in India. Or I might be doing something like allowing my platform to be used for selling and buying of the products. So we can look at the platforms with companies like Amazon or eBay offer in different economies. Or I might be a company which is just offering my platform for people to interact and collaborate with each other, something which a Facebook does. So all these companies are basically having specified digital transactions, and if you look at their business model, they do not need to be present in a particular physical environment before they decide, okay, this is going to lead to revenue generation. So it is not imperative on them that they have to be physically present in an environment before they can do business in a particular environment. And if you look at the language of Section 9, the connecting factors which Section 9 is talking about before you can say, okay, this is the income which can be deemed to accrue within this territory, you will not be able to find any connection there by which you can link the business model of these digital companies to the territory of India. So basically, whatever revenue they might be earning by doing business within this territory, this is a money which cannot be taken a tax by the Indian government. Now, this is not a problem which is, you can say, specific to the Indian territory. Most of the countries are facing a problem where companies who are digital or using digital technologies, or companies whose primarily model is based on the e-commerce, they come, they do their business here, and at the same time, they are not amenable to their tax jurisdiction. And one of the reasons for this is something which we call as that there is no permanent establishment of these companies within the Indian territory. Now, just to refresh here, if you look at the international taxation legal framework here, it talks about the concept of the permanent establishment. Now, this concept is basically saying that there is a threshold of the business activities, and if you're doing those threshold of the business activities, we are going to say that yes, you have a permanent establishment in the developing country, and then your business of profits are going to be amenable to the tax jurisdiction of, you can say, the Indian tax revenue department as such. So this is what they're going to talk about. But if you look at the business model of the digital companies, you're going to figure out that their activities, first of all, they will not be able to come within the language of Section 9, and over and above that, their conversation or their transaction is also not going to come within the language of the permanent establishment concept also. Now, let's say how the people are solving this issue. Is the OECD doing something about it? Now, if you look at the OECD conversations which are there, you're going to find out that many times the developing countries, they have given reservations to the OECD that it is very, very imperative now that the website should be recognized within the concept of the permanent establishment. That is, suppose there is a foreign company, and this foreign company is based in US, but it has a website which is specifically targeted at the Indian territory, and it is doing great business here. So this website should be taken equivalent to be a situation where this US company actually has a permanent establishment within the Indian territory. And if you look at the OECD, their adamant stand always has been that it is only where the server of the website is located, that jurisdiction is going to have the tax jurisdiction over any economic benefits which are being generated by the website. So the whole idea here is that the website is not considered to be equivalent to a permanent establishment. And though the Indian courts have been inundated by the income tax department by different cases in which the revenue has tried to create a scenario by saying that let us say that the website was a permanent establishment in the case, this has not been taking place. For instance, if you look at the famous case of ITO versus Light Florist Limited, it's a Kolkata bench judgment of the tax tribunal. Now there the revenue did come with an argument that, let us say that, you know, the website in this case, which was actually, and in this case the website was the Google and the Yahoo websites, and people were actually selling their online advertising services here, and they were paying money to the Yahoo and Google for the online advertising they were doing there. So they just wanted to raise an argument that these are the people who are actually doing business in India, and if money is being paid to them, this should be amenable to the jurisdiction of the Indian tax department. But the argument was not bought by the courts in the case for the simple reason that they interpreted this language which was contained there within the existing international taxation legal framework, recognized the OECD commentary and said that, okay, the website is not a PE within the current interpretation of the concept of permanent establishment as is understood across the globe. So the idea basically, I'm just trying to drive home the point is, if you look at the existing principles and the existing law which is present there, the website is not recognized within the PE concept. Now going forward with this, these are the problems which the OECD's BIPS project is also trying to solve there. Now what is this BIPS project about? The BIPS project has been, you can say, inspired by the conversation that you have multinational companies who enter into innovative tax planning arrangements, and then they do something which we call as the base erosion and profit shifting towards economies which are in the nature of tax havens. So where either the tax rate is nil or either there is no taxation at all. So you can just see that the international world is now trying to focus on the problems which are coming because there is just no taxation of certain type of income because the income cannot be identified in a particular jurisdiction. Now this BIPS action plan, which had been adopted in the July of 2013, it also has a 15 action plan, and if you look at the action plan 1, it is targeted for the digital economy. So it was in the October of 2015 that these people actually came for certain recommendations regarding, you can say, the digital economy. And just to name a few of them, they talked about that first of all, there has to be a creation of nexus-based rules for identifying significant economic presence. So please note, we are talking about significant economic presence. So if you look at the earlier taxation legal framework, it talks about you have a physical presence in the economy, and this physical presence can be identified by the connecting factors of the source principle or the residence principle. But now they are saying, in contrast to this, let's have a new concept called the significant digital presence in the first place. Now this significant digital presence says that maybe you are not physically present in an environment and doing business there, but you are digitally present. For example, Facebook is a company, you might say, is digitally present in the Indian economy, or Google, you can say, is a company which is digitally present throughout the world economy. The second is a withholding tax. Now obviously this is something which has been there in many economies, and we are basically talking about that a withholding tax is that we are going to identify, okay, this income has been generated within this economy, whereas because there is some digital presence, and then the source country, they can actually get a small portion of the pie there. The third is an equalization levy for specified digital transactions. Now this is the, you can say, suggestion we are going to focus more on, and we are talking about certain specified digital transactions. For example, you are a company which offers online advertising services. You are a company which offers online platform where business of selling and buying is done by third parties. So you are a company which is offering cloud computing services. So these are basically examples of specified digital transactions. Now what they are saying is, let's keep an equalization levy on them. The object is that maybe, you know, transactions are happening in economy, for example, buying and selling in the physical environment only. And the same buying and selling is also happening in the e-commerce world. So just to create a parity there, especially for the taxation of these transactions, let's have an equalization levy so that both the transactions should be there on the equal front. So there should not be an incentive just to buy something online because the taxation regime there is little flexible or it doesn't exist at all. Now, if you look at OECD, it's giving those suggestions, but at the same time, the OECD is also making the suggestions that all the countries who are going to adopt these suggestions within the domestic legal framework should be very cautious that they should not come into conflict with their existing treaty obligations.